Hello and welcome to this real estate webinar. My name is Robert Lusher and I'm a partner in the real estate team here at Russell-Cooke Solicitors. So rightly so, the focus recently has been all about COVID-19, the effect that this has been having on the real estate industry and the emergency measures introduced by government attempting to safeguard the real estate economy. However, today, and with the restrictions beginning to lift, I wanted to have a look at the new RICS code for leasing business premises, the details of which may have flown under the radar whilst we've all been managing the COVID crisis, and maybe particularly relevant, I guess, when we start coming out and fully emerge from the lockdown. So the RICS code for leasing business premises, first edition, was published in February 2020. For those who don't know, there have been various iterations of the code dating back to 1995, but for the first time the code is now an RICS professional statement, meaning some parts of the code are now mandatory for all RICS members. The new code will be effective from September 2020. So it kicks in then, and I suppose broadly speaking, looking at the aims of the code is probably twofold. Firstly, to improve the quality and fairness of negotiations on lease terms. Then secondly, promote the use of comprehensive heads of terms to make the legal drafting more efficient, but of course the code doesn't prescribe the outcome of those negotiations, but seeks really to make it a fair and balanced negotiation process, to identify the main terms that are usually important to the parties, and encourages the parties to seek advice from property professionals so that each party can make an informed decision about whether they want to proceed or not, and from an early stage. So moving on, what does it apply to? What does the code apply to? So the 2020 code will obviously apply to lettings of business premises, but there are a few exceptions to this. So the first exception set out in the code is agricultural lettings, premises used for housing plant or equipment such as telecoms, advertising media. This is intended to be wholly sublet, and short lettings of less than 6 months. So turning next to mandatory requirements. So this is set out in part 2 of the code, and these are the things that the RICS members are going to have to make sure they comply with. So first one is in relation to negotiations. Negotiations of the lease negotiations are to be approached in a constructive and collaborative manner. So not particularly prescriptive there, but hopefully all professionals will be operating on such basis already. The next item that is mandatory for members of the RICS is about notifying unrepresented parties about the code. So unrepresented parties must be advised by the other party about the existence of the code and its supplemental guide. It must be recommended to obtain professional advice. I think this is going to be obviously very important for professionals who are dealing directly with occupiers who, for whatever reason, don't want to or can't afford to instruct professional advisors to make sure that you've got a record, you've complied with those that element of the code. And the next main thing that RICS members are going to need to comply with is in relation to the heads of terms. So the code states that main terms of the lease must be recorded in writing, and as a minimum must include the position on each of the following. So the first one is the extent of the premises. So that includes a provision by the landlord to supply a land registry compliant plan. if the lease is indeed registrable, if it's over 7 years in length. In the heads, you're going to need to set out the rights granted, all the main rights granted or any special rights granted. So I think we're thinking things like parking, telecoms, rights to insert data, cabling, those sort of things. Next item is obviously the term, how long it's going to be, and whether it's inside or outside the Landlord and Tenant Act 1954. Let's need to detail any renewal or break rights. So whether the parties have a right to break the lease early or a contractual right to renew it. Whether there's any required guarantors or rent deposits. And then in relation to rent, there's a few requirements. So obviously you need to set out what the initial rent is. Also, you need to include all the frequency of payments, so whether it's going to be on a monthly or perhaps quarterly basis, whether it's inclusive or exclusive of business rates, whether VAT is payable on the rent, whether there's any rent-free period, or perhaps some other financial inducement. So that all needs to be included in the heads of terms. A rent review, that needs to be set out, so frequency and basis of review. Then service charge and insurance premiums, whether they're payable by the tenant or not. Heads need to cover alienation provisions, so rights to assign, sublet, charge or share the premises. Repairing obligations, so some leases may be subject to a schedule of condition. Use, so what the permitted use of the premises is, and whether any changes to the use are allowed during the term, if so on what basis. Alterations, so the rights to make alterations, and that's including whether the tenant has rights to make fit-out works, and in particular any specific reinstatement obligations, which I'll come to a bit later. And then finally, any conditions that the letting subject to, so subject to surveys, board approvals, planning consents, or other third-party consents. So, although there's a significant amount of information that now needs to go in the heads of terms, this is probably things that professionals have been used to including, but it's now important to make sure that any precedent heads of terms comply with that mandatory list. Turning now to part 3 of the code. This is in relation to lease negotiation best practice. So, section of the code is not mandatory, but if you do depart from it, you're going to need to justify the reasons why you do depart from it. Having read through the code, I picked out a few examples of practice. So the first one I picked out was rights granted. So the code refers to clear arrangements for special rights for electronic communications connections, including where necessary the right to require the landlord to grant wayleaves for data cabling. So it encourages, I suppose, landlords to be obliged to grant wayleaves for data cabling, and this is perhaps something that is quite commonly overlooked at heads of term stage or even in the lease negotiations. It encourages 1954 Act early notification to the tenant, so they can seek professional advice as to the implications of being inside or outside the Act. The rights and the conditions have been set out in the code, and unless the parties have, the recommendation is that unless the parties have agreed stricter conditions in the heads, the tenant's break should be conditional only on the payment of the basic rent before the break date, giving up occupation and leaving no subtenants or other occupiers. Disputes about state of the premises or what's been left behind can all be settled later. That's the recommendation of part 3. And landlords should also be required to repay the rent, service charge and insurance paid by the tenant for any period after the break takes effect. Again, all recommendations and best practice are not necessarily mandatory. Rent review. Well, this recommends the definitions of market rent should not result in a headline rent, which is probably fairly commonplace. Service charge recommendations of Part 3 refer to, as far as possible, making sure the service charge provisions in the lease comply with the service charge code. Next point I picked out was in relation to assignment, and whether on assignment an ARGA or a guarantee of that ARGA is required, and the recommendation is that it's only required where reasonable, so an objective test there. Alterations and reinstatement, this one I found quite interesting because the recommendation here was that effectively the position is that unless the heads of terms state there will be a reinstatement obligation, a tenant is allowed to leave alterations in place unless it's reasonable for the landlord to require their removal, which I thought was perhaps quite tenant friendly. So that's something to be aware of, and no doubt there will be reasons that landlords seek to ensure that reinstatement obligations are imposed on tenants. Part 3 goes on to recommend insured and uninsured damage provisions are included in the lease and provide for what happens in those circumstances, and that's fairly commonplace these days. It recommends green provisions being included, so provisions should be made to encourage cooperation between the parties to improve operational efficiencies and share available data. And the final thing that I picked out, and it is only a summary, is EPCs, and the lease should state which party is responsible for obtaining an EPC, and the landlord is to act reasonably if it reserves the right to choose which EPC assessor the tenant is to use. For completeness, Part 4 of the code does include some appendices. Appendix A includes the template, heads of terms, and a checklist of the mandatory requirements. Appendix B is a non-mandatory supplemental guide for landlords and tenants, including a checklist of occupancy costs, which may be useful for occupiers who are not familiar with standard lease terms. So finally, what are the takeaways? Well, I think although the majority of RICS members will probably already include the mandatory elements in their precedent heads of terms, it will no doubt be worth checking that any heads of terms that you are drafting covers all of the mandatory elements. Secondly, I suppose it's really a hope that when we do come out of lockdown, that this code aids the recovery by improving the efficiency of the lease negotiation process. I think it should do by focusing both parties' minds on the important terms of the lease, so that there's no last-minute abortives. Thank you very much for watching the webinar. I hope it's been useful, but if you do have any questions or want to get in touch about anything, then my contact details are on the slide. Thank you very much, and goodbye.